Welcome back to the second segment in this Rule of Law, Public Law session. Now, before the break, I gave you a range of ways to look at rule of law, and we considered it, or we looked at it from a philosophical, we looked at it from a political standpoint, and immediately before the break I said I'm going to touch on where most law students tend to start their work, and that's to do with Albert Van Dicey's rule of law's exposition. Now, to be fair, the general approach when you're coming to a public law exam, and certainly when you're looking at rule of law, is that you tend to get a question that sometimes says, or by and large, most of them tend to say, is Dicey's rule of law or the exposition of Dicey's rule of law still relevant? And so, of course, you need to know what is Dicey's explanation of the rule of law. Well, his explanation can be summed up with three broad principles, and frankly, this is the most widely accepted and debated view of the concept as it relates to the English Constitution. He says, the rule of law provides for one, that there can be no punishment unless there's a breach of law. Two, despite your rank or status, all are equal under the law. And three, rights and privileges are best protected by the common law rather than a Bill of Rights or in statute. Now, by and large, we will go through these three, but the fact of the matter is you tend to find that the first two are still of immense relevance today, but the third one is not as relevant and may actually be confined in time to the period when Dicey was writing. So let's start with no punishment without law. Well, the first principle mainly looks at the prohibition against arbitrary and retrospective legislation. What it looks at is that it is an inherently unjust state of affairs for a citizen to be punished for an act that was legal at the time he committed the act. Now, if the law said it was legal, then you not ought to be told later that it no longer is, and so you will now be punished. And although it wasn't a crime when you did it, now it is, and you are being punished for that. Well, that of course clearly shows, or arguably shows, that that is a contravention in respect of rights, and as such, a contravention of the rule of law. Now, even in Dicey's days, at the height of the sort of Victorian laissez-faire approach, and before Parliament became the dominant lawmaker, because it wasn't. What we had was, you see, this development of the common law over time. What we see is Dicey's insistence on a lack of arbitrariness and the absence of wide discretion, which he was expounded, did seem somewhat unrealistic. Now, you can see the basis for it, but like with anything, you're going to, of course, have some criticism, because the fact is that he was looking at it from the standpoint of, well, you should not, if you are the lawmaker, make something illegal and then hold me to that later illegal standard, when the fact is, when I did it, it was not illegal. Now, Sir Ivor Jennings actually critiqued that approach taken by Dicey, and he said, well, that doesn't really stand up to water, does it? Because any court can punish me for contempt of court by imprisoning me for an indefinite period, and if I am convicted of manslaughter, I may be released at once or imprisoned for life. If I'm an alien, my naturalization is entirely within the discretion of the Home Secretary. If the Queen declares war against the rest of the world, I am prohibited from having dealings abroad. And what we see, even with this point, is that, go back to contract law. When you look at some of the cases in contract law, for example, we see situations where, particularly in frustration, where someone has made an agreement with a company in a foreign country, subsequently there is a war with that country, and we find that there is an issue with it. The point is, Jennings is looking at it from the point of view of saying that Dicey's approach is somewhat simplistic. He says, if the country is in danger, my property can be taken also. I might not even get compensation. If a public health authority wants to flood my land in order to build a reservoir, it can take it from me compulsorily. I can be compelled to leave my work for a month or more in order to serve on a jury. All these powers and a lot more, he said, were possessed by public authorities at the time when Dicey was writing, which was in 1885. So he's saying it is somewhat simplistic to look at that first point and consider, well, it really should not be that you are subjected to certain types of laws if that was not the case when you started along the continuum. So back in 1885, we do see that even at that time, Dicey's approach may have been somewhat unrealistic. So looking at it, Jennings said, well, all of these things could have happened and can still happen as the case may be. Now, Jennings goes on to say that when you look at the lawmaking process, although the three component parts of Parliament, Commons, Lords, the Crown, must agree to legislation, this does not mean that arbitrary laws cannot be passed. Now, even if we go back to situations where laws have been passed, the one I'm thinking of is Picking and British Railways. Now, I'm not saying it's arbitrary, but the point that Mr. Picking was making was that it had not followed the procedure. Couldn't that be bordering, for example, on arbitrariness? Because again, at the time when Mr. Picking started on his foray of buying the next door land, it was not the law then that he could not get the land when the railway lines became disused. So Jennings points out to various situations, and not least the Defense of the Realm Act 1914, which he said, this act conferred wide-ranging powers on the executive to deal with the war situation. Now, the bills passed the Commons in one sitting, and it sped through the Lords as well. To that, of course, you can see the Official Secrets Act of 1911, anti-terrorism legislation in 2001, and a lot of these legislation, particularly in light of terrorism being in contemporary society a matter of some concern, we do see legislation moving arguably at the speed of light in going through Parliament. Might it not be that there is some comment to suggest that there may be a degree of arbitrariness? There's also, of course, the problem of retrospectivity, which Dicey condemned. To make a person liable for an offense, which at the time the act was committed was not an offense, he says, contravenes the rule of law. Well, that's why Dicey's exposition of that first point is still relevant, because when we look at the European Convention on Human Rights in Article 7, and remember that the Human Rights Act of 1998, which came into force in 2000, does actually bring over most of the articles, including Article 7. It doesn't bring over all of them, but it's, and we will discuss that in a later lecture, but it certainly brings over Article 7. And Article 7 prohibits the retrospective imposition of criminal liability. It is also a presumption of statutory interpretation that Parliament does not intend to legislate with retrospective effect. And of course, a case in support of this is Waddington and Meyer. Waddington and Meyer is a 1974 case, and it supports the concept of the rule of law and was a case concerned with the question of whether the Immigration Act 1971 was retrospective and whether it was contrary to Article 7 of the ECHR. The act was in effect retrospective, but the House of Lords in their ruling said it was not. Now, broadly speaking, the act at the time seemed to have been a somewhat racist approach being taken against Commonwealth citizens in order to control immigration into the UK. And the idea was that the way it was presented, it appeared retrospective, and certainly it said as much, but the courts were of the view that this certainly couldn't stand. Now, retrospectivity was also considered in respect of the case of Burma Oil and Lord Advocate. Now, the House of Lords denied the application of law with retrospective effect by using Article 7 of the ECHR when we look at the Waddington and Meyer case. But consider the Burma Oil case. Well, Burma Oil and Lord Advocates, we see here that it has a profound effect on the rule of law because Parliament subsequently passed the War Damages Act in 1965 based on the actual case, and by giving the War Damages Act retrospective effect, it effectively overturned the House of Lords decision in the case. And of course, there is an argument that it contravenes the rule of law, but this is where you get the rule of law having a conflict with parliamentary sovereignty, because by virtue of parliamentary sovereignty, albeit that clearly the rule of law appeared to be contravened, what took precedence was parliamentary sovereignty over the rule of law. So in Burma Oil and Lord Advocate, we see that the courts certainly was of the view that it was unfair and unconscionable for these persons to have lost their property at the hands of the government, and that the government ought to, for its part, compensate them. But what we see is the legislature, parliament, saying that is not the case and that will not stand, which of course bears out that parliament is supreme, and even as we consider the rule of law, does it take second place. Now, Dicey's second principle is that all are equal under the law. Now, this is one of the more misunderstood points in respect of Dicey's exposition of the rule of law. It is something that needs careful consideration, and in order to start that careful consideration, we will of course take a short break, and as soon as we return, we start off by looking at that second point in relation to Dicey's exposition of the rule of law.